Now it's my job to call the case, Long Lake Township versus Todd Maxon. This is a mini oral argument on the application. Both sides have 15 minutes to present their argument, and each have 2 minutes of a free fire zone, which you may waive if you choose, and you can reserve time for rebuttal, but we ask that you keep track of your own time.
Thank you, Chief Justice, and may it please the court. Oh, is it? Thank you, Chief Justice, and may it please the court. This case is about Long Lake Township's use of intrusive achieved with minimal, if any, social costs. This case presents this court a choice. It can keep the status quo, under which executive officials in this state have a blank check to use a drone to snoop around our private backyards whenever they want, for whatever reason they want, or it can hold that they may do so only when a neutral judicial officer agrees that there is good reason to do so. The court should take the latter approach, and it should apply the exclusionary rule to ensure that officials do not flout that rule. I'll start with the search question. I mentioned earlier the two tests that if the government violates either one, it has committed a search. I'm happy to answer questions on either test, but I'll start with the trespass test. The government has searched under the trespass test when it physically intrudes on a protected area in a way not licensed by the owner to gather evidence. No one here disputes that the drone was gathering evidence. In fact, the contract between the township and the drone operator is entitled, quote, "Proposal to Map Property for Code Enforcement." That's page 46 of our appendix. It was an unlicensed intrusion for Fourth Amendment purposes because the drone hovered at low altitude all around the Maxon's full property, including their home in Curtilage.
Do we know what altitude the drone was flying at? Is that in the record in this case?
We don't know exactly the altitude, Your Honor. We know that the drone was under 400 feet as required by law because that is in the drone operator's affidavit. And as the Court of Appeals recognized, drones fly below what is typically considered publicly navigable airspace.
Is that just, is that the dispositive piece of this? We know that precedent is really clear that a helicopter can hover around backyards and do some surveillance. Obviously, the United States Supreme Court has said so. Why is this any different?
Your Honor, I recognize the Florida versus Riley case. Florida versus Riley was applying only the reasonable expectation of privacy test under Katz. It was not applying the physical intrusion test that the court reinvigorated in Jones. As this court recognized in Johnson versus Vanderkoy last year, there was confusion from around that time that people thought Katz had totally abrogated the physical intrusion test. Jones made clear that was not the case and that the test that was applied in Florida versus Riley is not the only test that parties may raise and that courts can apply. And here, under the physical intrusion test, this was a trespass, whether under the common law rule.
So is it your belief those helicopter cases, could those also be trespass cases then?
I think if the parties had raised and the court had considered the physical intrusion test that we now know from Jones applies, that Riley would have come out differently under the physical intrusion test, yes.
And how would that mesh with sort of our modern understanding of airspace? Understanding this trespass theory is sort of this, from the core of the earth all the way to the heavens. How does that work with modern airplanes?
So I think we can look to the Cosby case from the U.S. Supreme Court in the 1940s that holds that even under the circumstances of modern airplane travel, low altitude intrusions with airplanes is as much a physical invasion of a property owner's rights as is an intrusion on the ground. And courts around the country in Pennsylvania and Virginia and North Carolina and Kentucky and Colorado, all of which we document at pages 21 and 22 of our brief, are having no trouble applying those principles.
I think those states, like I know at least in Colorado, they have a specific statute that specifically defines aircraft, and I believe drones aren't part of that. Is that accurate?
I think that was right in the Colorado case, but Fourth Amendment case law, whether Jones or Jardines or Collins or this court's decision in Johnson, is not dependent on whether there is a particular statute from that state holding that this was a trespass. Instead, all those cases are looking to general principles of property law. Jardines is not pulling a Florida statute or a Florida case out of the books and saying, yes, this is when that became a trespass. It's general principles of property law that control, and I think we can look to Cosby for that, as well as the unanimous view of authority from around the country. For its part, the township hasn't cited a single case holding that drones may not be trespassers at the 400-foot altitude or below that they must fly at. This was also a search under the...
Just so we're clear, according to your argument, when is or at what altitude is a drone flight over someone's property a trespass?
So I think we can look to Cosby. Cosby seems to indicate that the demarcator between publicly navigable airspace and where private property rights begin is 500 feet, because that's the altitude that airplanes cannot safely fly below. I think the same applies to drones as well. And our argument isn't that a drone over private property, the moment that it crosses over the property line even an inch, is necessarily a trespasser. I think we can look to Jardines, where the officers on the front porch in Jardines were not trespassers merely because they came an inch onto the front porch. As the court recognized, there is an implied license to approach the front porch by the front path, not quickly, wait to be received, and then, absent invitation to linger longer, leave.
But just so I'm clear, so if it's a private drone operator not hired by the government, would it be a trespass if someone flew a drone over my house at less than 500 feet? Whether they were there to gather evidence or not, would it be a trespass?
I think the answer that I'm trying to get at is that there very well may be a customary implied license in the future for drones that are recreationally, quickly and incidentally passing through another property, not for the purpose of gathering evidence or gathering as much information about that property as they can, or maybe Amazon's commercial drone delivery service, quickly and incidentally passing through. Wherever that implied license may eventually draw the line, what the drone did here, which was prowl all around the Maxon's property for the purpose of gathering as much information about that property as possible, this is on the far end of the trespass side of that line.
Counsel, I'm curious, sort of extending upon what you were talking about private entities. We live in an interesting world now where something like Google Earth obviously can capture images of all of our backyards. I guess under either strand, is the reasonable expectation of privacy now diminished because of that? And also, is that a physical trespass?
So I don't believe Google Earth is a physical trespass because that comes from satellite imagery, and that's up in outer space. I think that's clear that that's not...
Even if it gets really good and can zero in and pretty high tech?
I think under Cosby's reasoning, I have to concede that in outer space, there's no physical trespass. Under the reasonable expectation of privacy test, however, if Google Earth is capable of doing what the drone did here, which is provide full property mapping on a moment's notice from any angle at any time that the township wants, and I think that is a search, but Google Earth doesn't allow for that right now. If the township could have gotten from Google Earth for free what it wanted, it would have just done that rather than pay 4 figures of taxpayer money to a drone operator to do so.
But I think it's interesting because this is what we're grappling with, right? Technology is rapidly changing. I don't think it's hard to predict that eventually Google Earth will have that capacity.
I think that's entirely possible if that is publicly available in 20, 50, 100 years from now, then yes, there will be a diminished expectation of privacy if Google Earth is capable of that. But Google Earth is not capable of that right now. I concede there's no reasonable expectation of privacy from what Google Earth is currently capable of doing. The drone's capabilities far exceeded that, and that's why the township used the drone in the first place.
Since we're on to reasonable expectation of privacy, in addition to satellite imagery, the case law, Supreme Court case law has said that fixed wing, photographs from fixed wing aircraft flying in the publicly navigable airspace or helicopters, those aren't Fourth Amendment violations. Don't those things, in conjunction with the satellite imagery that's available, taking pictures apparently to the same quality, same level of detail, don't those diminish your client's expectation of privacy?
So I'd push back, Your Honor, that either Serrallo or Riley has blessed photograph surveillance from the air. Both those cases involved only naked eye surveillance. But Riley also,
What would be the difference between naked eye surveillance and a photograph?
So the difference is that what the township contracted here for was full property mapping of the Maxon's home. Riley and Serrallo blessed only what the naked eye could glance down and mentally record, as if they were a casual as if they were a casual observer simply passing through. What the drone is capable of is in hovering over the property for minutes at a time, taking photographs the entire time.
Let's do this hypothetical. What if the drone is flying at more than 500 feet and it uses readily available technology, camera technology, to take photographs? That, I think, according to your theory, wouldn't be a trespass, and it's in the publicly navigable airspace. Doesn't that, if you're allowed to do the drone, to fly the drone at that height and still capture those images, doesn't that reduce your client's expectation of privacy?
So 2 points in response, Your Honor. First is the drones may not be above 400 feet legally. The FAA standard is 400 feet or below. And secondly, Riley's plurality specifically says that the result would be different if the helicopter flights at issue there were contrary to law or regulation. And here, even under 400 feet, I think the drone flights and the drone surveillance here were contrary to Michigan statutes. MCL 750.539B prohibits trespassing on private property for the purpose of surveilling the owner's activities, and MCL 259.320 prohibits using a drone for something that would be prohibited if done by the person directly. So together, I think those statutes prohibit using the drone as an end run around what would otherwise need it to be a trespass to gather those photographs.
So the statute, though, doesn't say an activity. It says to capture photographs, video, audio recordings of an individual. And I think, how do you address your opposing counsel's argument that that statute isn't applicable? Maybe if it had, if the issue was having taken photographs or tracking an individual, like the Maxons themselves, as opposed to what physically exists on the outside of their property, visible to the naked eye from the air.
So 2 points in response, Your Honor. First, the statute that I'm referencing is MCL 750.539B, which prohibits trespassing for the purpose of surveillance, and 750.539A defines surveillance to include the owner's activities, not just the individual.
In order for that statute to apply under your theory, it needs to be a physical trespass. We would have to agree with you that it's a physical trespass.
Not necessarily, Your Honor, because read in conjunction with MCL 259.320, which prohibits using a drone for something that would be prohibited if done by the person directly. My argument is that the drone, in order to take those photographs without using the drone, it would have needed to trespass on the Maxon's backyard. So this is assuming even if the drone isn't a trespass, the township could have only gotten those photographs otherwise by trespassing. So those two statutes together would make this illegal under Michigan law if done by a private person.
Counsel, I just have a quick question. I always like to keep things relatively simple, and especially for our students here today, what would you say if this court was to not hold in your favor What would you say the far-reaching, I'm going to give you an easy one. What would you say the far-reaching implications would be for ordinary citizens, homeowners, et cetera?
I think, as I mentioned in my introduction, the court has a choice. It can keep the status quo, and if that status quo is maintained, property owners can expect drones hovering around the low altitudes of their backyard for whatever reason any government official wants. If the court holds that this is a search, the government may only do so when trying to gather evidence if a neutral judicial officer agrees there's probable cause to do so.
Counsel, I know our time is running short, and I don't want to let you go without asking a likewise sort of a practicality question. If we were to agree with you that this was a Fourth Amendment search, then obviously a warrant is required. We have lots of district court judges here who well understand how warrants get issued. Normally, in criminal cases, that's how the police execute a search. What would be the process here to get a warrant? I haven't figured out how you get a warrant in a case like this.
I see that my time is up. If I might just
Yes,
answer the
please.
question. The township could get a warrant the same way it would in any other case. It would have to build probable cause that there is evidence of some violation.
But do
and
we
it-
have a process for civil warrants that we can go? I procedurally couldn't find any avenue that they would get a warrant.
Oh, it would be an application to a judge the same way that it would in any other case. The camera case from the Camera versus City and County of San Francisco from the U.S. Supreme Court holds that even for civil code inspection searches, a warrant supported by probable cause is required. In the
Yeah,
township,
and I think in a lot of other states, they have statutory pathways. I'm just wondering, does Michigan have a pathway to do this?
to obtain a warrant.
For a non-criminal, for a matter like this, like a zoning enforcement action?
Your Honor, I'm not sure of any Michigan statute. I'm happy to submit a supplemental brief if the court finds that to be a dispositive issue. But I think the process would be the same as with any other criminal case. The government would allege there is probable cause of some violation of the law, and they would build their case the same way they would for any other case. It would, interview neighbors and friends, or rely on substantiated tips, or use publicly available information, submit that to a judge, and if a judge agrees there's probable cause, as the Court of Appeals said, the township could get a warrant to fly the drone all around the Maxon's property. We're here because it's half a decade later still insisting that it doesn't need that warrant.
Thank you.
Thank you, Your Honor.
Good morning, Madam Chief Justice, and may it please the Court. Bill Henn on behalf of Long Lake Township. The simplest and most direct way to resolve this case is to affirm the Second Court of Appeals decision, which held that the exclusionary rule does not apply. This Court doesn't even need to get to the merits of whether there was a Fourth Amendment violation, and the reason that is the most simple, direct resolution of the case is because there's only one case out there that applies the exclusionary rule outside of the criminal law context, and that is a case we've discussed. It's the 1958 Plymouth sedan case, and the reason that the exclusionary rule was applied there was because the civil forfeiture penalty was significantly more than the maximum penalty for the underlying crime. You don't have that situation here. This court should respect the fact that 1958 Plymouth sedan is the only example. Beyond that, if you get to the Fourth Amendment issue, the Supreme Court, United States Supreme Court, has held that visual observation is not a search. That's the Kylo case. However, even if this court applies the plain language approach that the defendants have advocated, which ascribes a meaning to search that's different than what the U.S. Supreme Court has, there wouldn't be a search here because you would still have to analyze the case under the Katz framework. The Katz framework is the only test that has ever been applied by the United States Supreme Court to an aerial observation. And under Katz, it's a two-part test. There's no violation under Katz because the defendants here did not exhibit a subjective expectation of privacy. There were no fences on their property. There was no roof or no awning over top of the items that were observed. Their property, their backyard, the back 5 acres, was not concealed from the neighbors. We have evidence that shows that all of this material that was accumulated was visible from adjacent properties. That's what started all of this in 2016 and 2017, was that there was a complaint that this was visible to other citizens in the township.
So Council, I'd just like to ask a question. That's my thing. I like to keep it simple. But the question I'm going to ask is if you could refer back to Brother Council's response. And I'm just curious, what would the ramifications be, the large scope ramifications be if the court were to ultimately adhere? He's basically saying that drones would be flying everywhere, all across the land. And I guess my question is, for the students that are here today, is this something that the court should be concerned about? Is this something that would ultimately impact? Would there be any kind of protections for our citizens? And that's really what I'd like you to address is like, if we hold in your favor, is this going to amount to what Brother Counsel said, that it would be basically open season for drones on citizens across the country?
I don't believe that there's any concern for that sort of alarm. I mean, I think it's easy in modern day culture and with modern day media to envision terrible circumstances where drones could be used in ways that are incredibly invasive. And the township has never taken the position that a drone could not be used in a way that could implicate Fourth Amendment concerns. Our position is simply that when you look at the facts of this case, the way that this drone was utilized, it's no different than what you've seen in Cirolo, what you see in Riley, the aerial observation cases that the Supreme Court has addressed. I mean, this kind of gets to the heart of our argument, is that even if you go beyond the subjective analysis in CATS, when you get to the question of whether the expectation of privacy is reasonably objective, I don't think that this court can get past the fact that we live in an age, and Justice Welch, your question was spot on, we live in an age where Google has mapped everyone's backyards. Not just that they could do it, they've done it already. And Google has a tool where you can even draw, if you want to know whether it's 50 feet from this house to this barn or 100 feet from this house to this barn, you do that right on the Google satellite imagery. And so given the reality of the world that we live in, how can there be a reasonable expectation of privacy in aerial observations of property? The pictures that the drones took here were absolutely indistinguishable from pictures that we downloaded from Google Earth. I would suspect if we didn't tell you which was which, you wouldn't know.
Well,
How-
what
how
about
do the-
I'm sorry.
How do the factors from Wolf play into our analysis? And do you think that they lead to the conclusion that the exclusionary rule should apply? I'm sure you're going to say no, but I'm struggling with looking at the Wolf factors, which tend to look at, or tend to say that the exclusionary rule would apply. How do you analyze that?
I'm not aware of any case that would suggest that the exclusionary rule would apply here. There's a two-part test, right? The first is, if you apply the exclusionary rule, what is the likely deterrent effect on future police conduct, right? It's clear that the exclusionary rule is not intended to punish for past conduct. It is a judge-made rule that is entirely intended to prevent future police misconduct. We don't have police involved in this case, but even if you were to consider the township zoning official as a sort of policeman, I don't think that the deterrent effect is very strong here because this is a civil proceeding. This case has discovery. There's no Fifth Amendment guarantee against
So
self-incrimination.
is that where the inquiry ends? I mean, do we just draw a bright line between criminal and civil? I mean, that might be the easiest way to do it. Is that what you're proposing?
I believe that's what the courts across the country have generally done, is the exclusionary rule. And that's what Judge Gleischer found here, was that there's only one example anywhere that anybody can find where the exclusionary rule was applied outside of the criminal context, and it was that forfeiture case, and there were unique facts in that forfeiture case that aren't present here.
Aren't they always tied to some criminal activity in order to become a forfeiture?
Correct. There's an underlying criminal activity, and the court found it in the 1958 Plymouth Sedan case to be anomalous that the civil forfeiture penalty would be so much more significant than the criminal penalty.
It's intertwined. The criminal proceeding is intertwined with the civil forfeiture such
Correct.
that the exclusionary rule came into play.
Correct.
But what about the cases now with bodily fluids, like drawing blood?
Well, this court has addressed bodily fluid cases. Those are, you're asking whether the exclusionary rule would apply?
Yes.
I think
I
there's
mean,
an
they pretty much, courts have said that they would apply there. How would you distinguish it? Because there's a huge difference between bodily fluids and a drone flying over property that's...
Well, I think that probably goes to the secondary component of the exclusionary rule analysis, which is balancing the societal interest versus excluding the evidence. And I think in those bodily fluid cases, courts have realized that that is such an invasive violation that it's almost beyond the pale. That there's sort of a visceral reaction to invading somebody's body that goes beyond taking a photograph from...
Even more so than invading the home.
Well, not invading the home.
No, I understand this isn't, but we have the home and then we have the backyard, and invading the body is even more intrusive than invading the home.
I think most people, if you had to create a hierarchy,
Yes.
I think they probably would say yes. They would rather have integrity in their body than in their home.
Was the trespass question fully developed and presented below into this court?
The theory of trespass is really interesting to me because, I mean, number one, I agree. The trespass test stands alongside the CATS test, but just because there's a trespass doesn't mean that you have a Fourth Amendment violation. I mean, what we're really talking about is what sort of trespass would give rise to Fourth Amendment concerns. It's not every trespass. I mean, this is the open fields doctrine, right?
My question is, was this fully developed?
Oh, I don't believe so. No, I don't believe in the trial court there was an issue about whether this was an actual physical trespass. I think that all came up on appeal.
And can we address the trespass without diving into air property rights? Don't we have to know what air property rights are first before determining whether this is a trespass?
I don't believe that you can address it without diving into air property rights. I also think that if you were going to conclude that that the Fourth Amendment standard in the state of Michigan is somehow equivalent to a common law trespass, you'd want somebody to bring a trespass action. You would want that record to be fully developed, and you would want to understand all of the nuances of trespass law. The Cosby case that counsel suggested, that's very different than what you have here because those were large military jets, 4-engine military jets that were flying 18 feet above the tree line on this glide path. There were 150 chickens that were so disturbed by that they flew themselves into the walls of the barns and broke their neck. That is easy, I think, for a court to say, yeah, that's a true interference with somebody's possession or enjoyment of their property. That sounds a lot like a trespass, certainly like a nuisance. This case doesn't bear any of those hallmarks. This is a drone that, until the third time wasn't even observed by the plaintiff. And I'll slip in here. The first two observations in 2017, the defendants had consented. They had applied for a permit, and as a condition of the permit, they consented to township inspection of their property. So I think that goes to reasonable expectation of privacy. When you invite the government to actually put boots on ground in that instance, right? I mean, anyone from the township could have physically entered their property on the ground and made these observations. You can't say that they have a reasonable expectation of privacy.
Counsel, I just wanted to follow up on sort of the civil versus criminal distinction that Justice Clement was asking about. Would it have made a difference here if there'd been cumulative fines? If you had said, you get fined $250 a day for not fixing the salvage that you discovered from the drone, would that have made a difference in this case? In other words, does that turn it into something that looks more quasi-criminal?
I don't believe it makes it criminal. I think cases have said even where there are civil fines, that's not considered to be a criminal penalty. It changes, I suppose, the calculus that there would be a cost to the defendant, but it's not considered a criminal matter, even though there's a possibility for a monetary fine. Now, I'll point out that the township here never sought any sort of monetary sanction against the Maxons. It was always just about injunctive relief and to enforce the ordinance. Any other questions? Well, I see that my time's not up quite yet, but I feel like we've probably covered everything. I guess I would just say in closing, Your Honor, that I would implore the court, when it decides this case, to do so not based on subjective views about whether you like drones or you don't like drones. I mean, these are polarizing things out there. Some people love them. My son loves them. I know people that don't love them, and they think they're the worst thing ever, and they're afraid of them. But don't let subjective fears, and particularly subjective fears about what might happen, how a drone might be used, because I think we can all admit that there would be circumstances, in the right case where a court would have no trouble, even the U.S. Supreme Court would have no trouble saying, yes, this particular usage of this drone raises Fourth Amendment concerns. It's not this case.
Can I get you back to, I think it was
Sure.
actually your opening, where you urged or encouraged us to decide it on the exclusionary rule and not necessarily wade into the Fourth Amendment violation issue. Now, if we were to decide the Fourth Amendment issue and say that it wasn't a search, we wouldn't need to get to the exclusionary rule, correct?
If you decided there was no Fourth Amendment violation, then
So
correct.
what authority would suggest that we can sort of assume a violation and just decide decided on the exclusionary rule? What would be the reasoning, or are there cases where that has been supported?
I don't know specifically in the exclusionary rule context, but I do know that courts, I think this court and pretty much any appellate court, when they're faced with a case that has multiple issues, if a decision on one of those issues renders the other ones moot, a court always has the discretion to say, well, because of our conclusion on this issue, we really don't need to address these other issues because it doesn't matter.
Sort of like analogizing, like in the qualified immunity context, right? That you can decide the clearly established prong without deciding whether or not
Right.
that there's a violation. But the Supreme Court has officially sanctioned that sort of process, right? That you can decide the second issue without the first. Is there authority that suggests that we could just decide it on the second issue as opposed to actually having to decide the Fourth Amendment violation?
I mean,
And
again,
can I just follow up on that? Because I think that one of the things that I'm struggling with is when you said just decided on exclusionary rule, there has to be an assumption made on the Fourth Amendment question.
well, I
We
think
can't we have to assume that there's not a violation.
I think what the court would say is that regardless of what our decision would be on the Fourth Amendment violation, our decision on the exclusionary rule would be that it doesn't apply because it's never applied anywhere in the country in this sort of circumstance. And so we're going to wait, until we have a case where the exclusionary rule issue is relevant before we dive into or before we start to untangle the Fourth Amendment knot. Your Honor, I guess, the last thing I'll say, my time's up, so I think I've said my last thing.
You can finish your thought.
With reference to the decision-making process, understand that the legislature has taken a look at this. They have taken the first pass at deciding, at balancing the public's right to use drones versus the individual's right to privacy from them. And as Justice Kavanaugh pointed out, the only thing that's prohibited is an observation of an individual engaged in an activity that would otherwise carry with it a reasonable expectation of privacy. I think, and I would implore the court to be deferential to the legislature's attempt to start to define these parameters. Thank you, Your Honor. It's been an honor.
Thank you very much. And we have used all of your time, but for the sake of the students, how about 30 seconds of rebuttal so they can see what that looks like? Do you have a question?
I appreciate that honor, I appreciate that in 2 points. One, a drone going to your property is not going to know whether it's going to see a person or whatever activities it's going to see, and that's why people have a reasonable expectation of privacy from drone surveillance on their property. The drone could see anything, and people don't know what that will be when the drone is deployed. And second, Your Honor, you were spot on in citing to Wolf. The issue in all of the civil cases on the exclusionary rule is whether the deterrence benefits would outweigh the costs, not whether the label is civil or criminal. And I didn't hear anything from the township explaining why the deterrent benefits would not outweigh the costs. Thank you.
All right, I just have one question. And can you respond to opposing counsel's point that you essentially don't have a reasonable expectation of privacy when you make permit applications and consent to inspection of the property?
I can, Your Honor. Black letter law on consent is that it must be specific and unequivocal, and the government cannot exceed the scope of valid consent. Even if my clients consented to an inspection of a perimeter fence around their property, that does not mean that they acceded to the scope of drone surveillance looking for code violations all around the interior of that property.
Okay.
All right, thank you
Thank you, Your Honor.
all, and the case will be submitted, and the court is adjourned.